I've been made aware also that this situation also applied for Treasury Board and the Mint. So the Mint recently changed their policy. So with some adaptation, everything here should be relevant for all of our workplaces. So just a recap to start, as you know, the vaccination mandate has become effective for most people. It will become effective quite soon for the Mint also. And where we are at right now is people that wanted to file a request for accommodation. They are in the process. The employer is in the process of evaluating that. And in terms of the member that are refusing to get vaccinated, they are in the 2 weeks period before the leave without pay starts. What is your best source of information? It's the Q&A, the FAQ on the PSAC webpage. It is updated on a regular basis, and it should answer most of your questions and most of the members' questions. So if there is, before you initiate anything, go there, read it again. Even if you read it last week, go there again. It might have been updated with more information. As you know, we don't have a lot of case law to rely on, and it's evolving rapidly. So when there is a new information coming up, new questions, we are looking into this, PSAC is looking into this, and they will update their website accordingly. Couple of common questions. What about teleworkers? So the policy includes teleworker, and the rationale for the employer is that they may have to attend scheduled meeting, events, access sensitive information, or address urgent operational requirement, and they are to be included in that mandate. Can the employer requires our member to be vaccinated? So physically, no, they cannot. No one can be forced to get a vaccine against their will. However, with the case law, the limited case law that we have right now, griever must live with the consequences of refusing to get vaccinated. So the counter argument here, also not the counter argument, but one of the main arguments for the employer are to keep the workplace safe. So we'll just take a few steps back and we'll go back to the basic. What is the duty to accommodate? Okay, so we've heard about it, you're dealing with it on a daily basis, but let's just remind ourselves what's important here. So employers, they have an obligation to adjust rules, policy, practice, even to be flexible with the collective agreement if needed. And this is a three-party obligation. It includes the griever, the member, it includes the employer, but also the union. Okay, so and the intent is to enable everyone to participate fully, even if they have a condition that requires some accommodation. An easy example is just listed here. Someone with visual disability, you can't ask them to do a written test as everybody else. Okay, so that's a one that everyone is quite clear about. In terms of vaccine, it's a bit more complicated for sure, but we need to keep that in mind. So the duty to accommodate is the obligation for the employer to make sure that everyone can participate fully, notwithstanding any ground of discrimination. But what are the grounds for discrimination? And what is discrimination? Okay, discrimination is the unfair treatment of a person or a group because of some grounds. Okay, and those grounds, there is a defined list. So the list is in the Canadian Human Rights Act and also in the collective agreement. And that list contains all of those that you can see right here: race, national or ethnic origin, color, religion, age, sex, sexual orientation, gender identity expression, marital status, family status, disability, genetic characteristics, and a conviction for which a pardon has been granted or record suspension. What does that mean? Is we have misconception that, well, I am being treated differently than another group. Quebec health workers are not forced to be vaccinated. I am discriminated against. This is not one of the ground listed in the Act. So therefore, for the purpose of a violation of the collective agreement and the Act, you are not discriminated against because of a certain group of the population is handled one way and you are handled another way, okay? So, and the employer did their own work on that end. So the vaccine policy does state that all employee must be fully vaccinated unless an accommodation is needed for one of the prohibited grounds for discrimination. Okay, there is no legal obligation for the employer to accommodate employees who have elected not to be vaccinated due to personal belief. Okay, because once again, personal belief are not one of the prohibited grounds for discrimination under the Canadian Human Rights Act. So that's important. And I think that you all know that by that stage, but it's really like to stress that unfortunately, where we are at currently, if for personal belief you don't want to be vaccinated, it's still going to happen. Like that mandate will remain in place as we know today. What are we expecting in terms of ground? We're expecting two grounds, disability and religion. So that are the big one that we are anticipating to have questions about. I just want to remind you that accommodation needs to be addressed on a case-by-case basis. All cases are different, and you really need to look at fact individually with one member. We'll try to provide you guidelines here, but those guidelines cannot be used as kind of rock solid. You don't enter in those parameters, you're done. You really need to evaluate on a case by case. So here that's super important, okay? You have a general obligation to provide true information to the employer. If the members are to submit false statement, that could constitute serious misconduct, and it may result in disciplinary action up and including termination. So it's far more serious than being placed on administrative leave without pay for a certain period of time. So if you have any doubt that someone is requesting or is filling a sworn affidavit that is not true, you should remind members, say, hey, I'm just reminding you that you have that obligation. Yeah, I know. Okay. I just want to remind you that there is consequences that are far more serious if you were to lie here than to say the truth. We'll start with disability. It's a tiny bit easier. You need to have a medical certificate, okay? If it's signed by a physician or a nurse practitioner, usually the employer will grant the accommodation. Just a reminder, certificate must not contain diagnostic. Like every other cases of a medical accommodation that we deal with, what we want is what's the functional limitation and certification by the doctor that it is linked to a handicap or a disability. The employer is requesting that the note specify whether the reason is permanent or time limited. So that's something that is acceptable. Same thing with you're coming back from surgery, you need accommodation for a certain time. It's normal that you provide that information to the employer. So don't forget here, needs to be evaluated on a case by case. It's not because someone doesn't have a medical certificate that it's an absolute no. Okay, so you could have extenuating circumstances where it would be acceptable to for us to defend a member that wouldn't have a medical certificate. First thing first, send them to the employer. I don't have a medical certificate, but I have all of those reasons. Don't make a call. Send them to the employer. Let the employer decide first, and let's play our role as safeguards here. So if it's refused by the employer, they come back to us and then we intervene. Now let's step into religion. This test is a bit more muddy in the sense that Supreme Court didn't put straight parameters in order to be able to be flexible, right? So, but that means that it's very difficult for you at a local level or at a regional level, even us at the national level, to be right on point. So we really need to pay attention and deal with those cases one by one. Okay, so what's the test? The employer must be satisfied that the employee hold a sincere religious belief that prevent them from being fully vaccinated. Okay, so that's that sincere religious belief that we are looking after. What does that mean? And the test, the Supreme Court test, is it's focused on the sincerity of the individual belief rooted in religion. It's not because you have a figure of authority of a religion that say, we believe that Catholics can be vaccinated, that automatically all Catholics can be vaccinated. If someone is able to demonstrate that their reading of the Bible, the way that they are dealing with their faith, would be a sincere religious belief that prevents them to be vaccinated, that would be acceptable in terms of case law. Okay, so the employee must explain the nature of the belief and why it prevents vaccination. However, the validity of the belief itself must not be challenged by the manager. The only thing they need to determine if the belief is sincerely held by the employee. Okay, and this is on their own toolkit. So if you have employers starting to challenge the validity of the belief, you can refer them to their own toolkit. It's black and white in their toolkit. The validity of the belief itself must not be challenged. What we're looking after is the belief is sincerely held. Case by case heroes also. You're not sure. What do you do if you're not sure it's a valid accommodation request? First of all, send it to the employer. Let them make the decision first. After that, if it comes back as a no from the employer, request the detail, follow the knowledge tree that we will explain later if needed. So I created also a link here to Canada.ca website that is a general process for manager. So this is intended for manager in the core. So this can be used also to say, look, here on your own guideline, Mr. Employer, you note here that you should not generally need supporting document for requests related to religious practice. Okay. However, if you're unfamiliar with a religion-specific religious practice, you can request additional information. But the information you seek should be focused on the need pertaining to the accommodation rather than the personal information about the employee. Okay. So here, what's going on? If the employer requests an additional information and you think it's too intrusive, request the details, follow the knowledge tree. So if you are not sure, do not hesitate to reach to either the chief shop steward if you're a steward, the local president, the RVP, and the RVP can refer to the national office. And if I'm not certain, I'll refer to PSAC also for determination. Don't forget that there is other grounds. We haven't seen a lot of those requests, but it would be the same general process as we do for all cases of duty to accommodate. So the member would need to provide an attestation on how their request for accommodation, it relates to a relevant prohibited ground. We let the employer make the determination first, and then if it's denied, we can step in and try to inquire, ask, and provide assistance. How are we handling questions and requests for membership? So general questions related to vaccination mandate, most of those questions are answered in the PSAC FAQ. Use the template email we provided to you a couple of weeks ago and send that to the member and stress, good, look, all of the relevant information is in there. If you get specific questions regarding the legality of the mandate, okay, you can reuse the same template email and just change it a tiny bit And you can add a general statement that PSAC explored all legal avenue and obtained legal opinions. Okay, the general statement is in the FAQ, and it says that there is a strong possibility that the government policy would withstand legal challenges that may be put forward. Okay, so that's the message that PSAC is sending to all membership. Okay, and we have had a briefing with PSAC. They did explore all legal avenue, individual grievances, group grievance, policy grievance, legal challenge, charter challenge, freeze period complaint. Everything was explored by PSAC and by their legal department and outside legal department. And the consensus is we have very little chance to be successful with recourse. Yes, but what about the Quebec healthcare workers or the Ontario that backtracked? It doesn't change the fact that we are bound by, in general, we are bound by the collective agreement, right? So the employer can manage their business unless they are restricted by the collective agreement. So that's generally how it works. We have nothing in the collective agreement regarding that topic. Therefore, it's management right. And as long as it's not completely arbitrary, discriminatory, or in bad faith, that's in a nutshell why PSAC believes that they will be sustained by board. Also, because we are starting to see few decisions coming from a couple of provinces on those mandates, and most of, not all of them have been withheld. There was no turn down of those mandates on those policies. So if you receive accommodation requests and questions regarding to this, send them to the employer. Send them to the employer first, make your request, provide the explanation, and if the employer refuses or asks for a clarification question, come back to us after. So in terms of request for clarification, so this, I spent a tiny bit more time in going into the details because it's something that we just recently found out, is that the employer is kind of intrusive in the questions that they are asking for religious belief. So there was a process here. You'll have access to the PowerPoint after the presentation, but generally make sure that the employer, the member, understand the consequences of lying in their sworn affidavit, as we've discussed. Go back to the employer and ask for the rationale behind the request. Why, Mr. Employer, are you asking all of those questions? What is it that makes you believe that this person doesn't have a sincerely held belief? Don't forget that in 2021, people are using social media without any protection a lot of the time. What do I mean is you have a lot of folks where you just go search their name on Google, find their web page, their Facebook page, and then you realize the employer can go and realize that there is a lot of posting about the COVID vaccine, but nothing is related to religion. Okay, so that's one way that the employer can gather outside information that makes them believe it's not a sincere belief. Okay, so they have doubts, and then if they have that kind of an information, another reason would be someone that publicly stated every year, I'm getting the flu vaccine, I'm going to get the flu vaccine, and then all of a sudden is saying that for religious reason they refuse to take the COVID vaccine. That could be a ground for the employer to investigate a tiny bit more. Or someone that is a known atheist in the office, and then all of a sudden is firmly believe that their religion prohibits them to take the vaccine. So those are the kind of behavior that the employer could use to dig in a bit more. Okay. All of that being said, there is still the principle of obey now, grieve later. Okay, there's very few exceptions to the rule, and answering those clarification questions will definitely not fall into one of those exceptions. What does that mean is you can push back on the employers saying that, well, we don't believe it's appropriate, all of those questions, but at the end, if the employers say, I want those answer, you should instruct your member to comply, stating that they disagree with having to provide that information and file a grievance. But it's important that they comply, because if they don't comply, the end result will be a denial of the accommodation first, be placed potentially on leave without pay, and maybe also face disciplinary investigation for refusing to follow an order. So just a reminder, we've talked a bit about the knowledge tree. Most of you knows what it is, but I just want to remind you, when you have a query, when you have questions related to any topics, but in particular representation, this is how it should proceed. The member asks a question to a shop steward. If shop steward doesn't have the answer, they refer to their chief shop steward. If the chief shop steward doesn't have the answer, they refer to the local president, who refer to the regional vice president, that then talk to us. And I talk with PSAC if I don't have the answer. Why is that? Because once we have the information once, we go back down the line. The next time the same question comes, it doesn't need to go back up. It would stop at the shop steward or the chief shop steward, right? So the purpose of this is really to empower all activists to have accurate and information and be able to answer directly to membership. So if all shop steward would go straight to PSAC, then no one in the structure will be educated that would know about representation. So there's two resources that we highly recommend. We've talked about the PSAC FAQ, but I also provided you with the link to a commentary, a legal commentary on the duty to accommodate that you can find on the Parliament website. And that talks in great details about case law. It talks about the accommodation for medical reason, disability, also religion, and it dives in quite deep in terms of what are the tests. Like if you want, like I want to know what the test is, where it comes from, what's the decision. Like this is multi-pages long that will guide you through that process. So I hope you like the format of this info session. Our goal was really to squeeze as much information as possible within a short period of time in order for us to be reactive also. So there is next steps coming up. As soon as we will have more information, we will provide it to you. Either it's in this format, kind of a bit more dynamic, or via email or documents or on the website. We will keep you posted on what's going on. If there is a change in PSAC, a significant change in PSAC instructions, we will let you know. If there is something coming up that we know aware, we will let you know. So thank you all for your participation. It was a great pleasure to have you here, and we'll talk to you soon.